All right, so yeah, so we are going to talk about press freedom today, and it's a little bit different from the presentations that we usually give on this topic, just because we have everybody here from all different sorts of. We have high school folks here, we have college folks here, public school people, private school people. So one of the things that we're gonna, that we'll kind of get into is that unfortunately, the Supreme Court is just kind of, whether you agree with what they've done with, the law affecting student press rights or not. The one thing I think we can all agree on, administrators included, is that the court has kind of made a mess of things. I mean, so unfortunately, there's just not. It's not like one law applies to all. It really does vary significantly, and varies sometimes significantly from school to school, particularly at the high school level, as we'll talk about in just a second. So that's kind of one of the unfortunate things about it here. But we're going to try and kind of jump into what the law says about for all of you folks here. We did talk about SPLC and what we do, so I'm not going to spend a whole lot of time. Here's where you can get in touch with me, though, on our website. Just our Get Legal Help button that takes you to our hotline, where you can either send me an email or you can set up a free telephone consult and we can chat about your issues. These presentations do always start, though, with the question, what is censorship? Because it really is an important question. I mean, we have all kind of, we know censorship from, if there is if school officials are going around collecting newspapers out of your racks, or just telling you just point blank you can't print something. I mean, that's one form of censorship. But I do want you to think about censorship in a much broader context, because courts have thought about it in a much broader context. Basically, what courts have said is that censorship is really any sort of action that is an attempt to control content, manipulate content, certainly, restrain content, anything that's an attempt to go after, to try and change the story that you're trying to write. So certainly we're talking about things like newspaper theft and all that kind of thing. But we're also talking about, one of the big things that we see all the time is cuts to budgets, where a school official says, you've just written this thing. As a result, you're not going to get the new printer you wanted, or you're not going to be able to go to a particular student media conference. That's censorship, where you can show that direct tie between their budget cuts, their changes to your travel plans, whatever, and something you've either written or threatened to write, or simply the fact that they don't like what the student media does generally, and they've made that clear. Where you can make that tie-in between cuts to budgets and content, that's what courts are looking for. Same thing, firing advisors, firing students, all sorts. I mean, they can get very, very creative, and particularly at the college level, as we're going to talk about just a little bit, where the law really is pretty protective of college student media. You really don't see a whole lot of really overt censorship lots of times at the college level. It really does take this form of kind of indirect censorship, like budget cuts and things like that. So as I said, we have all sorts of folks here. The first thing I just want to talk about is this whole kind of change or difference between public and private schools. When you look at the First Amendment, Congress shall make no law, it starts out. What courts have said in interpreting the First Amendment is that in order for the First Amendment to kick in order for the First Amendment to protect against censorship, there has to be some sort of government action. Congress shall make no law. There has to be something that the government has done to inhibit your right to free speech. So we have at a public school and a private school, at a public school, we have the school president or the school principal. They are all going to be government officials, and anything that they do is going to be considered government action. And so when they use their power as government officials to censor you, that's when the First Amendment kicks in. At a private school, unfortunately, because they aren't government actors, they're private individuals, there is not going to be any sort of First Amendment claim that you can make. Certainly, censorship takes place a lot at private schools, but it's not the sort of censorship that the First Amendment is going to be able to help you with. There are other sorts of legal avenues that you can look to for protection from censorship at a private school. One of the biggest ones is if the school itself has made any sort of promise to students. I mean, a lot of private schools, they have, very lofty sorts of like rights and responsibilities documents, a student media policy that perhaps they've voluntarily adopted. where they have made those sorts of promises, even though they don't have to, but where they have, courts have said that they can be interpreted as contractual promises that you can actually enforce as a contractual, agreement. So you have paid your tuition, and part of your deciding to go to that school and pay that tuition was perhaps because they did say that, they valued the rights of students to speak freely on campus and that sort of thing. So if you can find promises in there, again, there are student rights and responsibilities documents, sometimes even like their recruiting documents, any sort of really clear promise talking about, their, promise to protect the rights of student voices or student media in particular. We can look at that in terms of finding some protection there. But in general, the First Amendment isn't something that you're going to be able to rely upon at a private school. The other thing I just kind of want to hit real quick is this idea of the publisher. One of the big arguments you'll hear almost always from school officials when they try and censor is that, hey, we have the right to censor the student newspaper because we own it. We're the publisher of the student newspaper. It's really important that you blow that myth up really quickly. There is a big difference between the president of a public college or the principal of a public high school and the owner of the New York Times or the Washington Post. The biggest one is that the principal and the president, they don't own that publication, right? They simply are managing it on behalf of taxpayers. Taxpayers are the ones that are supporting it, typically taxpayers and sometimes advertising dollars, things like that. But the big thing to remember is that, again, the First Amendment, the whole reason behind the First Amendment is we are trying to limit the ability of government officials to interfere in our speech. We don't want government officials telling us what we can and can't say. And when you have a public school principal or public school president saying that, that's exactly the reason the First Amendment exists in the first place. We have this wonderful quote from this case, very famous college censorship case back in 1973, which, the university is clearly an arm of the state, and this single fact will always distinguish it from the purely private publisher. So, make sure that you don't let them sell you that publisher line very quickly. All right, so when we're talking about student press rights and pretty much any sort of student rights, you really have to look back to the beginning of it all. The Supreme Court back in the 40s, it actually kind of played around the edges of whether or not students had First Amendment protection in some cases involving the right of students not to have to stand to pledge allegiance to the flag. But it was really just, it was just kind of that one sort of tangential issue that they talked about. It really wasn't until 1969 in the Tinker case that the court really addressed for the first time the question of what sort of rights, if any, do students have when they are in school? Once students are in school, do they retain any sort of First Amendment protection? And, hopefully a lot of you have already heard kind of the facts of the case. It's a very famous case. It's in most high school history books and things. I studied it for a while in my law school class in addition. But basically the Tinker case took place. The Tinker family, they were a Quaker family. They were very much involved in the anti-war movement. And so when the Vietnam War started kicking up, and this was in 1965, is when the relevant story all took place here. But in 1965, they had one of the very first anti-Vietnam rallies that took place in Washington, D.C. And John Tinker, who was a 16-year-old high school kid at the time, went with his church group. They took a van out to Washington, D.C., and they took part in the rally. And apparently it had a really big impact on them. And so they were coming back from the rally, and they were in the van talking, and they said, how do we bring this home? How do we bring, what we have experienced here in Washington, D.C., how do we bring it home to Des Moines, Iowa, which is where the family was from? And so they decided that one of the things they were going to do is they were going to wear a black armband to school to mourn those that had been killed in the war and to protest the war generally. And so they decided on a date that they were going to wear it. A couple of days before it was time to wear the armband, school officials actually heard from a story that was written in one of the high school newspapers about this protest. And so they got together in an emergency meeting, and apparently it took place close to midnight, actually. And they passed this new rule that says you cannot wear black armbands. You can't wear armbands to school. And so the Tinkers, they had a decision to make. Mary Beth, who's in the picture here, she was 13 years old, and she talks about how at the time, her biggest claim to fame was that she liked to go roller skating with her friend. She was a very quiet, sort of shy student, but she said, she used just the little bit of courage that she had to wear that black armband to school. And so as a result of going to school, though, they ended up being suspended, and the case made its way all the way up through the court system, all the way to the United States Supreme Court, where, again, for the very first time, the court asked the question, when students are in school, are they protected by the First Amendment? And the court, in very famous language, said yes. They ruled for the Tinkers and for the other students there. They said that, in a very famous line from the case, that neither students nor teachers shed their constitutional rights to freedom of expression or speech at the schoolhouse gate. Now, it wasn't a unanimous decision. It was, definitely there was some contention, and I mean, one of the big sorts of things that concerned the justices there was just that they were stripping school authorities of their authority, of their power to kind of regulate student conduct. And so what they did is the two sides kind of got together and they came up with this balancing test, which we call the Tinker standard now. The balancing test the Supreme Court came up with is that they said that students have the right to engage in free speech on campus. They have the right to engage in expressive activities, except for two different circumstances. The first time that their speech would not be protected was where it was unprotected speech. And we'll talk about that in just a second, unlawful speech, basically. The other category, and this was kind of a category that was unique to students, as I said, school officials can also censor student speech where that speech creates a material and substantial disruption of normal school activities. And like I said, we'll talk about each of those a little bit here. The first one, unprotected speech. Basically, lower courts interpreting that standard have kind of, fallen upon the idea that we're talking about unprotected speech. Students don't have the right, like none of us have the right actually to engage in unprotected speech. There's just certain types of speech that over the years, courts have decided are simply just not worthy of First Amendment protection. They really don't add to the whole marketplace of ideas discussion. They don't contribute much to it. For example, libel. Libel is a false statement that seriously harms somebody's reputation. It's a false statement, so it really, again, it's information that really is of little use to the marketplace. And so they've just determined that defamation, libel, and slander are not protected types of speech. But there are about 15 to 20 sort of categories, depending on who you talk to, of unprotected speech that the court has recognized, and I've listed some of them here. And they're, again, if you're practicing, good bona fide journalism, you're usually not going to have problems with most of these here. The second category, though, is, like I said, it was unique to school officials, and they said that, or to schools, and they said that school officials could also censor speech if it created a serious, generally a physical disruption of normal school activities. The other thing is that they said that in addition to creating that material disruption, any sort of forecast of that disruption has to be reasonable. School officials can't just say, if you publish that article, I think it might create some problems. They actually have to have some pretty good evidence. When students published an article on that topic at this school, this happened. There were riots in the hallways or something like that. They have to have some pretty good evidence that the speech that you create, that you publish, it would create that material and substantial disruption. We actually had a good example of what sort of speech might meet that standard a few years ago. You'll remember the March for Our Lives protests, where students, decided they were going to walk out of class and have protests, outside of school to protest guns and gun violence in schools. We got a lot of phone calls at the time. They took typically kind of two different forms. One call said, we've heard about this, March for Our Lives protest that's coming up. Can we do just a straightforward news story on what it's all about, and how things are maybe a local effect or something like that? And the answer to that question was typically yes. As long as you were just writing a straightforward news story on it, you probably would be able to do that. The next question, though, was, can we write an editorial that that advocated, that suggested that students actually participate in these March for Our Lives protests. And that would be one of the times where school officials probably could step in and say, no, even under Tinker, you probably don't have the right to write an editorial that says, next Wednesday, there's going to be this class walkout. We urge all of you to take part, walk out of class and gather at the flagpole or whatever it's going to be. School officials could say, and I think, with some pretty reasonable forecast here, that if you publish that editorial, students are going to listen, they're going to walk out of class, and there's going to be some serious disruption, of normal school activity. So that's the sort of level that we're talking about under the Tinker standard. So again, students have the right under Tinker to publish as long as the speech is both lawful and non-disruptive. And so that was really the law that was in place for many years. And really, Tinker really did change everything. I mean, it really did have an impact. It continues to have a monumental impact on what we do, in this country. It was really because of the Tinker case, that in the early 70s, when protests started really taking off on American college campuses, that's why college presidents had to allow that protest. I mean, it was the Tinker decision that required that. There's been something like 6,000 different courts that have cited Tinker over the years in support of student speech rights. So it really did, it had a significant impact. And pretty much it came up anytime there was any sort of student speech issue. So, there was lots of cases that came down after Tinker involving student media, but also lots of cases that had an impact on, the right of students to engage in theatrical performances or to, hand out flyers, or pretty much any sort of expressive activity is what you would see the Tinker case listed pretty early on. So that remained in effect for about 20 years, until 1988, which was when the Supreme Court started getting involved again. They'd actually gotten involved one time before, but the Hazelwood case was really the first time where they got involved specifically with student media. So the Hazelwood case took place at a high school, Hazelwood East High School, just outside St. Louis, Missouri. They had a newspaper there. The student newspaper was called The Spectrum. And the Spectrum had a problem. Nobody was reading it, the student said. So this is the fall of 1982, the 1982-83 school years when all this kind of happened. But they got together at the beginning of the school year and they said, you know what? Nobody is reading our paper. We're working lots and lots of hours on it. Nobody's reading it. And they really felt that the reason was it was kind of a rah-rah sheet. It really was kind of just an extension of the school's PR office. They talked a lot about, dances and how great students were doing and testing. And I mean, it was just a lot of kind of happy news, they said. And so they said, we want to change that. We want to actually have a newspaper that discusses relevant issues. So they got together at the beginning of the year and they said, we're going to do something a little bit different from what we've usually done. And they decided they were going to put out a special section on sort of teen issues at the time. And so a couple of issues that they wanted to start with. One was the impact that divorce had on students. And the second one was the issue of teen pregnancy. And that's kind of, you can see the actual article here that ended up being censored. But Hazelwood East High School had a number of students at the school that were pregnant. And they said, you know what, let's do a story about, what is it like to be in high school and pregnant? What sort of resources are available? What's that whole experience like? They actually went and they interviewed lots and lots of social workers and medical professionals, counselors at the school. They also talked to some of the students at the school that were pregnant and got their story. And that was really, I think, the thing that set the principal off when he first saw the story. And that was another part of the issue that took place here that's relevant, I think, is that in between when the students decided that they were going to create this special issue, and when it was actually time to go to the printer, they had a change in advisors. The advisor of the student newspaper was actually the head of the union at the school, and so as a result, apparently was butting heads with the principal and other administrators on a regular basis, and just got fed up and said, life's too short, I'm out of here. So he quit. It had nothing to do, at least directly, had nothing to do with the student newspaper. But the result was the students lost their longtime advisor, and a new advisor was brought in. And the relevance of that is that this new advisor came from a school where prior review was the practice, was the standard policy at the school. So prior review it's a legal term, and prior review means just reading only. It's typically mandatory prior review. So if administrators say before you go to the printer, we have to read and approve that. That's prior review. And so that's what had taken place at this advisor's previous school, and that's what happened when he came to Hazelwood East. He took the paper and just automatically gave it to the principal. Principal saw it, and again, he'd never seen a Spectrum newspaper like this one. He was used to a lot of fluff news, and here he had a story front and center on teenage pregnancy. And I think the only kind of way to describe it is he freaked out. I mean, he really, when you read some of the depositions and stuff that came out of the case, it's just clear he was not ready for this. He thought that discussing teenage pregnancy in a high school newspaper was simply inappropriate, and he wasn't going to have any of it. And so he ended up censoring the paper. Now it's interesting to note that when this paper was censored, the students actually called us here at the SPLC. Now I wasn't quite here, but they did say, that they received information from us that said, you know what, hey, the law at the time is Tinker, and so we would have applied the Tinker case, the Tinker decision to this issue. And when you read it, was there anything unlawful in it? No, it was a legally clean piece. There was really nothing in it that was libelous. There's some question about some privacy concerns, but at the end of the day, it was a legally clean piece. The next prong of the Tinker case is, is this the sort of article that would create a serious physical disruption of school? And the answer to that was no. I mean, all these, students might see this and they say, well, this is new. Haven't seen this in the student newspaper before, but they're not going to engage in class walkouts or fistfights or anything like that. So under Tinker, it was actually a really easy case. But the school refused to back down. And so the case went all the way to the Supreme Court. And here's Kathy Kohlmeyer, who's one of the plaintiffs in the case. And when it got to the Supreme Court ruled, unfortunately, against the students. And what they did is they said, they did not overrule the Tinker case, and that's significant. What they did is they distinguished it. They said these are two different sets of facts, and they require two different types of law be applied to them. They said in the Tinker case, Mary Beth's armband was non-school sponsored. She had made it with her family on her own at home. In the case of the Spectrum newspaper, though, it was part of a class. There was an advisor that was paid. The school itself, paid some of the printing bills. Oops, sorry about that. And as a result, two different types of law should be applied. The Tinker standard applied to non-school sponsored speech. The Hazelwood standard, this new Hazelwood standard, would apply to school sponsored speech, at least at the high school level. And we'll talk about its impact on colleges too in just a sec. So under the Hazelwood standard, this new standard that would apply to school sponsored speech is that school officials could now censor speech where they determined that their censorship was reasonably related to a legitimate pedagogical concern. Basically, is there a reasonable educational justification for the censorship? That was the new standard. We didn't know exactly what that standard meant. All we knew is that it was going to provide significantly less of an obstacle for school officials to overcome when it came to censorship. And certainly it did. I mean, one of the things that the Supreme Court did is they gave some examples of what they figured would constitute, would meet that reasonable educational justification standard. And among some of the things they said is that schools could censor speech where they determined that it was, quote, poorly written. And I want you to notice every one of these little phrases here is in quotes because it's taken directly out of the Hazelwood decision. So the Supreme Court is saying that school officials can now censor speech if they determine it's poorly written, biased or prejudiced, unsuitable for an immature audience, which was what the Hazelwood East principal was saying. It was just not teenage pregnancy was not a suitable topic, ungrammatical material that would associate the school with anything other than neutrality on matters of political controversy, or my favorite at the bottom there. And this is the United States Supreme Court saying this. I mean, in a First Amendment case, it really is it's just mind blowing. They said that these government officials could censor speech where they determined that it was, quote, again, this is a quote, inconsistent with the shared values of a civilized social order. I mean, it's just nuts. It's absolutely nuts that that's kind of where we are. And we'd really not seen a language like this out of a First Amendment case. except for one instance before, and it took place the year before. So Hazelwood was 1988. In 1987, the Supreme Court issued its decision answering the question, what sort of rights do First Amendment rights do prisoners have when they're in prisons? What sort of authority do prison wardens have when it comes to censoring prisoner speech? And when you look at the language out of that came out of that decision, that prison wardens can censor speech if their censorship is reasonably related to a legitimate peniological interest. So you see, they just swapped out the educational interest for the peniological interest, and wham, we have a new First Amendment case. So it's important to know, I think, where your rights come from as students. Now, what about college student media? And this is really, I mean, this was a huge question going into the Hazelwood case. Is what was going to be the impact on college media? Tinker had been applied pretty much to student media across the to student media to student speech across the board. High school media. Mary Beth herself was a junior high school student when she wore the armband to school. So pretty much, the court had never really distinguished between different, levels of students. But here they said that they did pull back, and they said, we're not now going to decide whether the same degree of deference is appropriate with respect to school-sponsored activities at the college level. So they basically punted. They said that we're not now going to decide whether or not, this Hazelwood standard, the standard that lets school officials censor things because they declare it's poorly written or inconsistent with the shared values of a civilized social order. They said that we're not now going to decide that, whether or not that's appropriate at the college level. I mean, thankfully they didn't do it. But the fact that they even, that they didn't immediately just say, of course, it's not the appropriate standard, was very alarming. And so we waited, and we knew that the cases were going to come, and they did. The first case the first college Hazelwood case that we had was a case that started in the late 90s. It was resolved in 2001 in the Sixth Circuit. And basically what happened in this case, and this was a close call, I mean, and it's unbelievable. This is what Hazelwood looks like at the college level, is the administrators at the school censored the yearbook. And this is actual, you can't really see it, but it's a picture of the yearbook cover. They censored the yearbook, claiming that the cover of the yearbook color did not match the school colors. That was one of the reasons they used to censor it. The other was that it included a current events section. And they said that, the yearbook ought to focus just on events at our university and shouldn't have, talk about, what happened, in the news outside. I mean, that was a reason. The cover of the yearbook color was wrong, and they had this current event section. And the thing is, the court, the appellate court that first heard this case, they applied Hazelwood, and they said that was sufficient. School officials actually, college officials had the right to censor this based on Hazelwood. Luckily, it was appealed further on, and an en banc ruling ended up with the language that you see here, which was consistent with, language that we'd seen before and that we fully expected to see in cases like this. But it was a close call. I mean, we had a court of appeals in 2001 before it was overruled by a full court of appeals that said that Hazelwood is the appropriate standard at the college level. We hoped that was the end, but it wasn't. A few years later, we had another sort of case that came up. This involved a student newspaper called The Innovator at Governor State University, just outside Chicago. And it wasn't a very good newspaper, I'll be honest. It wasn't, great journalism. But they, and they were definitely a thorn in the side of the university. And as a result of that, the school officials called up the printer and said, you are not to print any more issues of The Innovator until we have looked it over and approved it. And so anyway, the case, students ended up suing, going to court. And here we do have the Seventh Circuit. So this is the circuit that covers Illinois, Indiana, and Wisconsin, that has said that Hazelwood provides our starting point. And that remains the law. That case, there was an attempt to appeal it to the Supreme Court. They didn't hear it. They didn't agree to the appeal. But so we do have a case on the books right now that says at the college level, Hazelwood is the starting point when you're looking at censorship cases. Luckily, we've had some developments in Illinois. At least Illinois passed, as a result of this Hazelwood case, they passed a law specifically addressing the rights of college student media and basically reversing the impact of this decision. But it remains, an issue that we're going to have to deal with going forward. Uh, so one of the things we saw as a result of the Hazelwood case was just this, this alarming rise in the number of phone calls that we got at the SPLC. SPLC in 1988, we were getting around about 500 phone calls for legal help a year. By the 10 years later, that number had pretty much quintupled up to close to 2,500 calls a year. So Hazel is just bad news. I mean, it's bad news for everybody. It's really bad news for high school media, but it is potentially problematic for college media to the degree that it's going forward. Right now, we do have really, really good law on the books that we think ought to counter Hazelwood in most states, but we do have this issue that's out there. A couple things to remember though with Hazelwood is it only applies to school-sponsored speech. It's 2021, and in 2021 there's lots and lots, obviously, of non-school sponsored speech that's available. Some of you may remember seeing in the news this past summer this case that came out of the Supreme Court involving Brandy Levy here, who is a cheerleader at Mahoney High School, and she tweeted off campus at a convenience store on a Saturday afternoon her unhappiness with not making the school's cheerleading team, and as a result, she tweeted some profanity and gave the middle finger, that sort of thing. As a result, she was suspended and told she could no longer, cheer for the school team. And so she sent out that tweet, or that Snapchat, I guess it was, kind of expressing her unhappiness with that. She was suspended, told she couldn't be a participant on the cheerleading team. Ended up going to the Supreme Court. The Supreme Court ruled for Brandy. They said that, when we're talking about off-campus speech, non-school sponsored speech, that school officials really have very little authority over that. So important to remember that Tinker definitely does not, or Hazelwood definitely does not apply to off-campus speech like that. The Hazelwood standard also has some teeth. I mean, it's not great, but there is some case law out there that has pushed back a little bit on this notion of, having school officials having a reasonable educational justification for their censorship. They actually do have to have a reasonable educational justification for the censorship. And there have been a couple cases, at least, where courts have questioned that and said that school officials have met that burden. The other thing is that Hazelwood doesn't apply to what we call public forum student media. And I'm not going to go into a whole lot of detail about that because it gets a little complicated. But one of the things that because of what Hazelwood has said there, is that we've seen this increase in the amount of protection that students can look to outside of the First Amendment. Either school districts or states themselves have passed laws that essentially set student media up as these public forums. They called New Voices laws, which maybe some of you have heard about. But basically a New Voices law is an attempt to kind of turn back the clock. So New Voices laws were initially called anti-Hazelwood laws because they were specifically a reaction to the Hazelwood case, and lawmakers and journalists and educators and students in those states said, you know what, the Supreme Court went too far. They really did. The Hazelwood decision was just kind of this bridge too far, and so we want to give back to our students some of the legal protections they had prior to Hazelwood. So states can never pass a law that provides less protection than that required by the First Amendment. They can always pass a law that provides more protection. States can always give, or school districts can always give their students more free speech protection than that provided by the First Amendment. And that's basically what these New Voices laws do. They essentially give back to students the same sort of protections they had under Tinker. Initially, these laws were written specifically for high school kids. The laws that have been passed recently as a result of some of the, like the Hosty case that we just talked about, the college cases, the newer versions of these New Voices laws do include protections for college students as well. So far, 14 states have passed New Voices laws. We are hopeful that we're going to have a 15th state in the next few months, at least, out in New Jersey. But if your state is on here, one of the first things I will always ask if you're calling, with a censorship question is where are you calling from? Because if you're calling from one of these 14 states, hopefully soon to be 15, I'm usually going to have some good news for you. As we just went through, I mean, Hazelwood itself, it is not a great news sort of case. It really does give school officials, a lot of authority, and if they are smart, if they just have use some common sense, they can probably come up with a justification that's going to pass muster under Hazelwood. These laws really change that if you have a new voices laws, I'm probably going to be able to help you out and get you out of your censorship problem. Basically, they again, they provide censorship protection for both high school and colleges. Rhode Island actually has protection for private schools, which is kind of interesting. They also provide liability protection for schools as long as school officials don't involve themselves in content decisions, as long as they aren't effectively, giving the paper the school's official seal of approval. These laws say that the school district's deep pockets, the bank accounts of the school districts, aren't going to be subject to invasion by a plaintiff. That the liability would stop with the students themselves. The other thing that a lot of these laws have is job protection for advisors, because one of the things that we've seen is that, while they might not directly go after the student newspaper, as we talked about before, there are, one of the ways they can kind of indirectly censor is going after advisors. And so we've seen a lot of, we have seen a lot of, advisors losing jobs, being transferred away from their journalism jobs as a result of standing up for their students. And these laws say that can no longer be done. And I think we're getting close here. Just a few quick ones. What to do if you do get censored. The first thing that the biggest sort of defense that you will always have, always by far, is just doing good journalism. Is if you are willing, if you're writing work, if you're putting out work that you're willing to stand up publicly and try and defend, that's going to always be your biggest sort of asset in terms of fighting against censorship. Having a story that's well reported, well written, well researched, that you truly do feel comfortable defending. That's always going to be the number one sort of defense. Letting students lead as opposed to advisors, that's also really important. Advisors are just on shakier, at least legal grounds, than students when it comes to contesting censorship. And so having students understand what their rights are, having students be the ones to set up the meetings with the administrators to challenge their censorship, having students be the ones to reach out to news media and that sort of thing is always very, very helpful. And I think, really does, it's the thing that's going to freak school officials out the most, I think, is if they know they actually have to deal with students as opposed to their employees. Knowing your rights, which we're doing today, using the court of public opinion. Lots of these cases are resolved not so much in a court of law, but by simply, pointing out that censorship is taking place. Censorship is still is still kind of a bad word, thankfully. And so, at least holding censors accountable has always been a very helpful thing to do. And then exploring alternatives. Again, it's 2021. There's lots of different ways of getting a story published and getting it out there that don't involve having to go through the school-sponsored student newspaper. So knowing that those are out there and taking advantage of those have proven very, very helpful in some circumstances.